to take the photos. On the left-hand side, we have the evidence leaders, and the defense team is just on the way now. They will be here with the National Commissioner. She will also be here. So just that 30 seconds, you take whatever photos that you take, and then you resume your places. I'm just requesting for that cooperation. Thank you very much.
We didn't went to what? Need some people to
this is for the one that you're carrying. So I want to give to them. The evidence here. So I want to put this together. Yes, the evidence here. I think that's the one that you're going to use for government now. So can I give it to them? Yes. Okay. Thank you.
I think we can start. Good morning, ladies and gentlemen. Welcome to the first day of this Board of Inquiry, which has been set up by the declaration in Government Gazette by the President. And I'm Judge Nels Johnson. This is Advocate Susie Kutswana next to me, and also Advocate Brody on Port Elizabeth. Thank you very much. And, we understand, Mr. Jamie, that there will be some initial argument which we will have to resolve. So would you
My name is William Mukari Singh. I am instructed by Westminster attorneys on behalf of the National Commissioner of Police, Riah Phiyega, who is on my right, and on my far right is my instructing attorney, Mr. Sandy July. Thank you.
Thank you. Yes.
Mr. Judge, can I proceed? Now we finish, Judge.
Please.
Judge, as indicated in Chambers, there are two issues that arise from preliminary arguments. The first is whether the eNCA is entitled to call witnesses who were not called at the following emission, and if so, what manner that may be done. And the second issue is the scope of the inquiry into the National Commissioner's Witness Office, in particular, whether that is limited to the actual evidence that she read at the following commission. And those are the two issues I'm going to deal with. I'll only make reference both to our statement of case and the statement of response, and to
And the second of the defense.
together with the evidence. It would make it easier to follow the argument if those are before members of the board. Is that all possible?
Well, I understand that our secretary did ask which files would be required for this new hearing, and apparently she was told no file would be necessary for this first round of hearing. And then we grew apart to that conversation.
I think the understanding was that it was the files were the various files of the trial. We thought these would, the very naturally before you when you're sorry about the submitting one in that regard. It just will make it a lot easier. You have those documents before you.
Sorry, Judge, if I may come in, from our side, we need to make things much easier in anticipation of the argument on these two points. We prepared those documents that we believe will be relevant many copies that we've made for the panel, and we have already given the same copies then to our colleagues. The only thing that they will not have will be the statement of case and the statement of defense, but everything else, including the statements of the witnesses that they want to call, will be in this panel. So if we can just end up through the field.
Yes, and I wonder if we can ask our secretary if she can possibly fix our files so that we can have them here in regard to the status of the case.
In fact, my change has been that they also prepare the statements which you can hand out as well, and then make the life of everybody easier.
But in the meantime, I'd like to proceed opposite, and we'll see to it that those files are being fixed.
Opposite. Judge, the news report. The first issue, namely the witnesses of the evidence. Because to do so would be repetitive and a waste of time and resources. We've got no quibble with that statement. Then paragraph 55. It may however be that one of the parties requires a particular witness to be called, despite that witness testified at the following commission. But the calling of such a witness should be limited to clarification in respect of his or her evidence at the following commission, not the rehashing of the evidence he or she has already led. And to the extent that it's suggested there that the only purpose of calling witnesses who have already testified at the following commission would be to clarify the evidence, but they cannot lead further evidence, we take issue with that proposition. Paragraph 55 then goes on to say the following, and this is perhaps the nub of the issue between the parties at this point on the evidence that may be led. It is, however, impermissible for the evidence leaders to call witnesses who were at all relevant times available to testify at the following commission but were not called, or to call witnesses who testified at the following commission in order to bolster the evidence which they've already led at the following commission, which is really a repeat of the previous proposition. But the important point is the assertion that it is impermissible for the evidence leaders to call witnesses who were at all relevant times available to testify at the following commission but were not called. And then it goes on, and it concludes, paragraph 55, any attempt by the evidence leaders to call the witnesses as they have alluded to in their statement of case will be opposed. And we read that to mean, it seems, all the witnesses. So, hence the need for this ruling, members of the board. Our first proposition is that it is not clear on what basis these assertions are made, and no authority or basis therefore is set out. But when regard is had, to begin with and we know this is an inquiry that has been established by the President in terms of Section 9.1 of the Police Act. Section 9.1 reads, members of the board, subject to this section, subsections 1 to 8 of Section 8 shall apply mutatis mutandis to any inquiry into allegations of misconduct by the National Provincial Commissioner or into his or her fitness for office or capacity for executing his or her official duties efficiently. Now, you will be aware that all three of those sub-paragraphs or sub-parts of 9.1 are at issue in this case. They are all referred to expressly in the terms of reference of this Board of Inquiry. When one goes then to Section 8, which has been incorporated by reference in 9.1, 8.4 provides in broad terms for the rights of the commissioner concerned, who can be a provincial commissioner or a national commissioner, in this case, the national commissioner, at such an inquiry as this, She may be assisted or represented by another person or legal representative. She may make written representations to the board. She may be present at the inquiry. She may give evidence thereat. Cross-examine witnesses not called by him or her, be heard. And then G, call witnesses. And that is an open-ended authorization. She may call witnesses. And then H, have access to documents relevant to the inquiry. And then sub 5, which is also incorporated in 9.1 by reference, is important. The Board of Inquiry shall determine its own procedure. Now, members, this board has done that in its rules, which have been adopted. And I wish to refer in particular to, and the rules deal separately with the rights of the evidence leaders, the procedural rights of the evidence leaders, the commissioner, and third parties. And 2.1 under the broad heading of submissions in the rules says, the evidence leaders shall, by date directed by the board, file their submissions, which should include, and in 2.1.1, statements on oath by persons who are able to depose to any factual allegations made in the submissions. And once again, that is an open-ended authorization to the evidence leaders to submit, together with their submissions, which you have, statements of witnesses, factual statements, which support what is alleged in the submissions. And there is no, obviously, apparently, from what I've just read to you, there is no restriction of the sort suggested by our colleagues across the hall. Then in 2.2, it's the Commissioner's rights, and they are in the same wording, file submissions which should include statements on oath by persons who are able to depose to any factual allegations. And the only restriction is the person to be called must be able to depose to factual allegations. And then, in the case of third parties, it's the same regime under 2.3 and 2.3.1. And then, just to finish on this topic, under the heading hearings in part 3 of the rules under 3.3, it provides that any party, and party is defined as including third parties for purpose of these rules, but they include the evidence leaders and the defense. Any party may, through the Secretariat and after approval from the board, call upon any competent and compellable person to give evidence on any relevant aspect of the terms of reference. And we submit that that provision is dispositive of the argument that we have, that we are in some way, without understanding how that comes about, limited with regard to the evidence that we may call. We submit that there is no basis for that, and that subject to relevance, the evidence leaders may call any witness who can testify in support of any of the terms of reference. And I'll obviously respond when I hear the argument, but that is our submission in respect of the first point. The second point. The second point is the scope of inquiry into the National Commissioner's fitness for office. This arises, members of the board, from paragraphs 160 and 161 of the statement of case, where on page 102 of our submissions we deal with this fifth leg of the terms of reference. And we say the following there, in 160, the evidence leaders interpret this term of reference, and you'll recall the term of reference, Judge, is whether the overall testimony of the National Commissioner at the Commission was in keeping with the office which he holds and the discharge of the duties commensurate therewith. Now we interpret that term of reference to refer not only to the manner in which the National Commissioner testified, but to the substance and content of the testimony. And that's what we say in 160. That is, whether such evidence demonstrated a proper understanding and appreciation of her role as National Commissioner. And then in 161 we say the following. Secondly, the evidence leaders of the view that the inquiry into the National Commissioner's fitness for office requires a consideration not only of a testimony of the Farnham Commission, but also her interaction with the Commission in general, and her representations to the President in response to the findings and recommendations of the Farnham Commission, and indeed her interactions with this Board of Inquiry. We accordingly deal with these aspects in our submission hereunder. I see and know that the National Commissioner is present. I didn't have the opportunity to greet her, but I just want to make clear, in making these submissions, we don't suggest that she would or interact any other than properly with this board, but I'm using an example to demonstrate why the argument against what we say cannot, with respect, be correct. If, and let's leave it at the level of supposition, if the National Commission, either in dealing with the Farnham Commission or this board, acted in a manner that is objectively dishonourable or in some other way not consonant with her duties as National Commissioner, it would be an absurd and indeed perverse situation that this board would be, because of a literal interpretation of the term of reference 5, be limited or have to ignore all of that and simply look at the evidence that she gave. And we submit that is not what was intended by the President in setting up this board, and it is not the way the term of reference should be read. We submit, in line with recent Constitutional Court and Supreme Court of Appeal jurisprudence with regard to the interpretation of contracts and legislation, that the term of reference 5 must be read purposively and not literally, otherwise it could lead to the sort of absurd results that I've just postulated. And we say such a reading of term of reference 5 is compelled inter alia about the relevant constitutional provisions, and I would like to refer the members of the board to section 207 of the Constitution, which provides that the President, subsection 1, provides that the President, as head of the National Executive, must appoint a woman or man as the National Commissioner of the Police Service to control and manage the police service. That person stands at the head of this organisation and must lead by example. And you will, with respect, examine her interactions inter alia with the Farnham Commission in the light thereof. The second provision that I want to refer you to is section 1995 of the Constitution, which falls under the...
Which section?
199 sub 5, which falls under the general heading of security services, of which the police obviously is one. And subsection 5 says, the security services must act and must teach and require their members to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic. And that again gives the proper context, constitutional context, we submit to the conduct and an examination of the conduct of the National Commissioner. She's not a low-level functionary whom we can excuse shortcomings or certain shortcomings, etc. She must be held with respect to a high standard. And we submit the interpretation that we contend for would give effect to that, and not the one contended for by our colleagues. And there are two particular aspects that you'll be aware of them from having read the statement of case that we rely on in support of this, our interpretation of this term of reference and how we intend approaching it and dealing with it. And they are what we refer to at page 108 of our statement of claim as the Riah incident. And you'll recall what that was about, members of the board. That was the expert witness who, it would appear, do I need to elaborate on that, Judge? Do I need to elaborate on that? The incident? I think you should, yes. Very well. The River incident is dealt with on page 108 of our statement of case. And what we say there in page 108 from para 173, we make the point that at the commencement of the Farnham Commission, the National Commission undertook that the police would give its full cooperation to the Commission. And that is recorded in the Farnham Commission report. And in 174 we say this was not the first occasion on which such an undertaking had been given. In the aforementioned media statement of 17 August 2012, the National Commissioner concluded the media statement as follows: the police will give their full cooperation with any investigation into this tragic incident. And then in 175 we say that notwithstanding the above solemn undertaking, it has now transpired that the National Commissioner, acting personally, instructed a legal team not to cooperate with the Farnham Commission in respect of a crucial part of its work. In this regard, we attach here to, as Exhibit EL5, an email sent by the police attorney to the National Commissioner and inadvertently copied to the other legal teams of the Farnham Commission. The email reads as follows: Dear National Commissioner, I'm instructed by the legal team to communicate this letter to you. We refer to your letter dated 10 June 2013 conveying the instruction to the legal team that the SAP's management declines the instruction of the chairperson of the Commission that various expert witnesses must hold a conference of experts to identify areas of communality, differences, and reasons for holding different opinions on a particular point. We hereby express our regret that the instruction of the chairperson of the Commission is misunderstood. The legal team has on several occasions attempted to explain that the question of which witnesses are to testify and how their testimony is to be rendered to the Commission is a legal question to be answered by the legal team. It is not a matter on which SAPS as a client can give instructions purported to be done in this correspondence. We must emphasize that Mr. De River is an independent expert, is entitled to express his professional opinion without any interference, influence or instruction. What Mr. De River cannot do is to direct how his evidence is to be presented before the Commission. We implore the National Commissioner to reconsider this instruction and to revert to us. And we then say in 176, it is clear from the above email the chairperson of the Commission, Judge Farnham, had instructed that the various experts should meet in order to identify areas of commonality, differences, and the reasons for such differences. This is common practice in legal proceedings where there are different expert opinions. The National Commissioner, acting personally, instructed a legal team to decline that the SAPS expert, Mr. De River, attend such meeting. She persisted in this position, notwithstanding several attempts on the part of the SAPS legal team to persuade her that her stance was inappropriate and unjustifiable. This inadvertently disclosed communication from the attorney for the SAPS to the National Commission indicates that the latter, notwithstanding our undertaking to cooperate fully with the Farnham Commission, took a conscious decision to frustrate the proper conduct of that Commission in a crucial respect and without having any justification. Therefore, in the absence of any explanation that the National Commission may be able to furnish for actions in this regard, it is submitted that this conduct on her part on its own demonstrates her unfitness for the high position that she holds. Now, that is a highly pertinent and serious allegation that is made, and it would, we submit, this Board of Inquiry would not be carrying out its function were it to simply ignore that, because that is not evidence. It's material that arises directly from the interactions with the Farnham Commission, and we submit we are entitled to rely upon it. The second aspect is the statement in her representations to the President. She was afforded an opportunity, as you know, after the Farnham Commission report, to respond to the report, and she provided a document which is an annexure to our statement of case, and in that document we refer to it at pages 119 and 120 of our statement of case. I'm sorry, let me just... Sorry, it's at 120, not 119, 120. It's under the heading, the National Commission's unwarranted attack or tax on the Farnham Commission. And there we say in para 198, We have referred in paragraph 72 above to the assertion by the National Commissioner in a representation to the President that the following Commission made a finding that can only be regarded as malicious in its content and scope, quote unquote. This assertion is to be found at page 13 of the representations. We say that we deal in our submissions above with why the conclusions reached by the following Commission in respect to the National Commission's assertions are far from being malicious, in fact, entirely correct. However, the point for present purposes is that for a public servant like the National Commissioner to accuse a judge of the High Court, and in fact, my apologies, it's a judge of the Supreme Court of Appeal, of malice, is in the absence of compelling evidence to support such contention, prima facie evidence of unfitness for office. Albeit that Judge Farland was presiding over a commission of inquiry, it is submitted that the following provisions of the Constitution are relevant to this issue, and we refer then to 165 of the Constitution, sub 2 and sub 3. That the courts are independent and subject only to the Constitution and the law, which they must apply impartially without fear, favour or prejudice. No person or organ of state may interfere with the functioning of the courts. And we then say in 202 that to accuse a judge who is exercising judicial or at least quasi-judicial functions at the appointment of the President of the Republic of malice is a serious charge which, if unwarranted, reflects adversely on the office and judgment of the person making such charge. In the present case, for the reasons aforesaid, there is no basis for alleging malice against the Commission, and in particular against Judge Farland. The evidence leaders submit that by making this unwarranted attack on Judge Farland, the National Commission has provided further evidence of her unfitness for office and an inability to carry out her duties in accordance with the law. I just want to refer the members, well, that actually goes to the merits, so I'm not going to deal with that. But we submit these are two highly pertinent issues which arise from the Commissioner's interaction with the Farland Commission, and in particular her representations which she submitted was in effect a foreshadowing of her response to this board. She then gave, as it were, her reaction to what the Farland Commission found. And it would again be, I use the word deliberately, it would be perverse to ignore her earlier response and to treat this as a tabula rasa. That would simply be putting blinkers on your eyes and would prevent you from getting to the bottom of the question of whether or not the National Commissioner is fit for office and able to carry out her duties efficiently and according to law. And if authority is required, and can I just make this submission, even if you are against us on the submissions we make on the second ground, then there's another basis upon which we should be allowed to refer to her earlier representations, and that is something that all of you will be well aware of, is the law of evidence relating to previous statements, inconsistent statements. And if any authority for that is required, then if I could refer to Schmidt, Law of Evidence, at page 9-60, where the author says the following: albeit in the context of criminal law, although the footnote is to a civil case, although it is perfectly permissible during cross-examination to ask a witness whether he has previously made an inconsistent statement, he may not be questioned about an inadmissible statement in this manner. And we're not dealing with an inadmissible statement. And the authority for that proposition, members of the board, is the case of De Wet versus President Verzekeringsmaatskappij Beperk, 1978, 3 SA 495C, at 498, where in civil proceedings, previous inconsistent statements made to the police and to the criminal court were put to the witness. This is standard procedure. And that is the comment by Schmidt. So, either on the basis that it should be admissible on a proper interpretation of term of reference 2.5, or alternatively on the basis that To the extent that or if the National Commission testifies at this Board of Inquiry, we should be permitted to cross-examine her on her response. We submit it should properly be before the Board. Those are our submissions.
Mr. Mukari.
Thank you, Judge Klassen and the members of the board. I would like to start by having some form of sequence in my argument. I'd like to first refer you to the correspondence, which I'll do. And then the next topic that I'll deal with, I will refer you to the terms of reference, which establishes this board. And the third point, or third topic, I will deal with the statement of case as we have it from the evidence leaders. And the fourth point, then I'll deal with the evidence that the evidence leaders seek to be permitted to lead.
Just say that again, please. The last point.
At the last point, I will deal with the evidence from the statements that the evidence leaders are asking permission from this board to lead. Well, I'm referring to this last topic precisely because the submissions that have been made have referred to no single statement of any of the witnesses that they want to call and why then that has to be accepted. And that is actually what they were supposed to do. Then let us start with this bundle that we have handed up to you. I see that the index says index of correspondence. Maybe it would be appropriate, with your permission, Chair, for identification purposes, refer to it as the correspondence bundle.
Let us just mark it as Exhibit A.
Exhibit A. Thank you, Judge. So Exhibit A consists of the minutes of the meeting of 18 January 2016, and that was the preparatory meeting convened by yourselves in order to ensure that everybody understands the precise scope, the nature of this inquiry, and the procedure that is to be followed or contemplated by this inquiry. Then from the second item, then we have correspondence which ensued between the evidence leaders and ourselves as the defense. But I'd like to, without really going through much of the correspondence, to take you to item 27, which is page 81 of that document, of that bundle. And this now will be a letter from Waxman's attorneys dated 28 April 2016. If we can quickly look at that letter so that we can understand the scope of the arguments pertaining to this particular point. In this letter, which was a culmination of a teleconference which took place between the respective parties' legal representatives on Thursday, was recording the discussion. Then it says, we address this letter to you to confirm a teleconference discussion that took place between our counsel and the evidence leaders this morning, 28 April 2016. It was agreed between us and our counsel
that we will address this letter to you confirming the discussion. What was agreed between our respective counsel, the agreement which we align ourselves with is that, 1, the evidence leaders will raise 2 in limine points at the commencement of the inquiry on 3 May 2016, which are whether the evidence leaders are entitled to call witnesses who did not testify at the Farnham Commission of Inquiry, and 2, whether the evidence leaders are entitled to rely on evidence which occurred after the Farnham Commission of Inquiry had been concluded, such as the representations which were made by the National Commissioner to the President. The above mentioned points will be argued and the ruling will be made by Judge Claassen. Our client's position in relation to the above, which was also communicated to the evidence leaders during the teleconference, is that the evidence leaders are bound by the terms of reference which established this inquiry, and therefore they are not permitted to call witnesses who did not testify before Farnham in order to augment or bolster a case that was never made before Farnham, and are also accordingly not permitted to rely on evidence which occurred subsequent to the Farnham Commission of Inquiry. With this letter that I've just read out to you, then that should take us to the next point that I'd like to argue, which is the terms of reference. Because in that letter, we specifically refer the evidence leaders to the terms of reference which we say are bound, then bind this inquiry and bind all of us who participate in it. If we can just look at these terms of reference, I don't know if we have them then before you, but I will read them out because they are of critical importance right from the first paragraph of it. The terms of reference contained in the schedule, which have subsequently been amended, and I'll come to the amendment when I argue in a different context. It says, whereas on 26 August 2012, I appointed a commission of inquiry chaired by Honorable Judge Ian Farnham to investigate matters of public, national, and international concern arising out of the tragic incidents at the Lonmin mine in Marikana, Northwest Province. And whereas the commission has finalized its investigation and submitted its report to me. And whereas the commission inter alia recommended that steps should be taken in terms of Section 9 of the South African Police Service Act 1995 to inquire into the fitness of Commissioner Phiyega, the National Commissioner, to hold office and whether she is guilty of misconduct. And whereas the National Commissioner was invited by me to make representations regarding the report and the recommendations of the Commission and has in fact done so, now therefore, 1, in terms of powers vested in me, in terms of Section 9 of the South African Police Service Act, I hereby establish a board of inquiry into allegations of misconduct by the National Commissioner and or into a fitness to hold such office and or into a capacity for executing her official duties efficiently and according to law. 2, the Board of Inquiry shall inquire into whether 2.1, the National Commissioner acting together with other leadership of the South African Police Service or alone misled the Commission by concealing that it had made the decision to implement a tactical option taken at the National Management Forum meeting on or about 15 August 2012. 2.2, in its amended form, whether the Commissioner, in taking the decision to implement the tactical option, ought reasonably to have foreseen the tragic and catastrophic consequences which ensued. 2.3, the remarks by the National Commissioner at the SAPS parade on 17 August 2012 would have been understood to be an unqualified endorsement of the police action and thereby having the consequence of undermining, frustrating, or otherwise impeding the work of the Commission. 2.4, the report prepared by the National Commissioner for the President of the Republic on the 16th August 2012 and the media statement subsequently issued on 17 August 2012 was deliberately amended to conceal the fact that there was 2 shooting incidents, Scene 1 and Scene 2, resulting in misleading the public that all the death had occurred at Scene 1, which arose out of members of the SAPS having to defend themselves from an advancing mass. 2.5, the overall testimony by the National Commissioner at the Commission was in keeping with the office which she holds and the discharge of her duties commensurate therewith. So, these are the terms of reference which were prepared and issued by the President of the Republic of South Africa in terms of the powers vested in him by Section 9 of the South African Police Service Act. And these terms of reference cannot be changed by anybody else but by the President. In fact, this point was alluded to in one of our strategy meetings with this board, where you made it very clear when we were contemplating whether term of reference 2.2 reads quite well in order to give meaning, and then a submission had to be made to the President for the President to amend it, and this board of inquiry could not even on its own, despite the powers vested in it by the President, to amend it. Not even the evidence leaders could amend it. So we know that the terms of reference are there. They delineate the scope within which this inquiry must take place, and they have to be respected also by the evidence leaders. But I would like to demonstrate as well, when I move to the third point, that even the evidence leaders, when they prepared their statement of case, they understood that they are constrained by the terms of reference, that the statement of case must conform and must be compatible to the terms of reference. They understood that they cannot go outside the terms of reference. They understood that very well. And let us see how they understood it. So now I'm going to the third point of now looking at their statement of case. So if you can then take the file which was, then the Ashliver files which I handed to you, which contain the statement of case as well as the statement of response. I'm not sure the statement of response is not there. The file, the Ashliver file that which you handed up. Okay. But in any event, I will read the relevant paragraphs of the statements of case which I'm referring to, if then you do not have them in front of you. Apparently then I'm told by my attorney that the files then contain other statements. I was intending when I was asking my attorney to make available the statement of case and the statement of response, because they were not made available by the evidence leaders then for your attention. But I will read the relevant paragraphs. You can just note then the paragraphs which I'll read out. Before I read the paragraph, then let me say also the following, which will also assist in ensuring that we understand how this inquiry was contemplated to be proceeded with. It was also in one of the strategy meetings agreed that the evidence leaders will put together a statement, And that statement is what they gave us, and they called it a statement of case. This statement was to delineate the parameters and to make it clear to us as the defense and to this board what is the case that they want the National Commissioner to meet today. So the National Commissioner also, in terms of the agreement, she was required to file a statement of response in answer to the statement of case, which she also did. But let's look at page 9. That is now the tabbed pages which I'm referring to, because both the statement of case and the statement of response are not paginated. So I'm referring to page 9 of the statement of case, paragraph 3 at the top. This is what the evidence leaders say. An inquiry in terms of Section 9 of the SAPS Act is akin to a disciplinary inquiry and is structured as such. The terms of reference set out the scope of the inquiry. It is clear that this is not a general inquiry into the fitness of the National Commissioner. And that is what we were told by the evidence leaders. But it is confined to the conduct of the National Commissioner in relation to the events at Marikana and her evidence in relation thereto at the Falam Commission. And that is what they're saying in paragraph 3. The inquiry into General Phyega's fitness for office arises from the adverse findings made by the Falam Commission. So now, the evidence leaders understand when they write this paragraph 3 that there are terms of reference which constrain them activities. So with that,
Mr. Mukari, may I interrupt you again? Just
Yes.
a question. Are you suggesting that actions, conduct, or statements by the National Commissioner ex post facto the Farm Commission, which is related to the Farm Commission, should therefore be excluded from this inquiry?
yes, we say, so in the context of the manner in which the terms of reference have been crafted, because they make it specifically clear, if we can go back to the terms of reference, that these terms of reference are in relation to the events at Marikana and the evidence that she tendered at Marikana. So if there's anything which happened outside the Marikana, that is after the Farm Commission had issued its report, that is information which in any event was already within the knowledge of the President, and nothing prevented the President from putting it in the term of reference. But the manner in which the President has put his terms of reference, he closed it into the events of Marikana. If I give an example, for instance, of what Mr. Jamie referred to by the representations that the National Commissioner made to the President after the report was issued. The representations at the time when the President prepared these terms of reference were with him and he was aware of them. And what now the evidence leaders are doing is to now extend the scope then to say that she actually then misled and she lied to the President. But that is not what the President is saying in the terms of reference. Because if the President believed that the representations misled him or that she was lying to him, he will have then put it as a term of reference so that it can be then properly dealt with. So we're not talking of something which was not within their knowledge or something which then happened after the terms of reference had been issued. So there is a context to it. So the context then must be the President has made it clear what he wants the parameters of this inquiry to be. So if, for instance, the evidence leaders wanted the terms of reference to extend to whether the representations to the President were misleading, they'll have simply then gone back to the President and say that we want you to extend the scope of the term of reference and include this particular point. The same way, oh, sorry. So, yeah, so what I was saying is that this is a particular event which, if the President was complaining about, he would have put it as a term of reference. The same way as when we had a problem with term 2.2, we had to go back to the President. I remember that, Chair, you even wanted to find out if then there are any other amendments which have then are contemplated, and it was clear that that was the only one. And since that time, we have not seen or any request that the terms of reference must be expanded. And I am not saying that the President cannot expand his terms of reference. And I'm not even saying that he can't amend them. He can even amend them to include some of the things which many people were saying in the media. There were some who were even lobbying that, he must include all sorts of things, that it must be a wider inquiry which deals with all sorts of things about her conduct. But the President stuck to his guns. He said that these are my terms of reference and no other.
Mr. Mukari, if the National Commissioner were to testify in this inquiry, that would be evidence which she submits ex post facto the Farm Commission, not so?
Yes, that's the evidence that she submits ex post
All right.
facto.
Well, now, why should we then take cognizance of her evidence ex post facto the Farm Commission tendered at this inquiry, but not any ex post facto statements she made or representations she made which concerned her conduct regarding the Marikana and Farnham inquiry?
Well, the answer to that, Chair, is that as the evidence leaders have considered, as I've pointed out to you in paragraph 3 of the statement of case, that this is the parameter that they understand to be that this inquiry is a disciplinary inquiry per se. So in a disciplinary inquiry, the employer will be bound by the charges as he has put them unless he amends them. But the employee is entitled, as a matter of fact and law, to defend himself or herself and to adduce whatever evidence which will persuade the presiding officer that she is innocent. So we're talking of two different parties who are not standing on the same pedestal. The employer is standing on a pedestal where he has made his case clear that I am accusing you of A, B, and C. And he can't come and say that I'm now accusing you of D when then he comes to the inquiry. But the employee is entitled to adduce whatever evidence, to come with evidence which the intention is to persuade you as the presiding officers that I am not guilty of this conduct. So we're talking of two different things. So the evidence leaders cannot place themselves in the position of the National Commissioner because she does not have the onus of proof. They actually agree that they have the onus of proof. She only has the duty of rebuttal. So when she rebuts, she can rebut by adducing evidence which will persuade you. Mr. Jamie actually then made submission about if the National Commissioner testifies, for instance, that he will be entitled then to cross-examine her about subsequent events. But then he's talking about a completely different context. Because now you're talking in the context of cross-examination. Cross-examination is broader in its nature. You can cross-examine a witness about anything as long as you are able to show what you are trying to solicit and in relation to the relevance. So that will be cross-examination. But we're talking about the case that she's supposed to meet, not when she's been cross-examined. Of course, when he cross-examines her, he can cross-examine her about anything, and he can even test her suitability by making reference to some of the remarks that she has made. There's nothing wrong with that. And we understand that perfectly well. So in that context, then yes, we understand and we accept that. So the point that I'm making is that the President makes it very clear that these are the terms of reference. And if the evidence leaders believe that they've got difficulty with the manner in which the terms of reference have been crafted 8 months after they've been crafted, then they are not explaining to you why until today they did not go back to the President and say, Mr. President, we want you to include a term of reference which will allow us to adduce evidence to show that she is not fit even post-Marikana because she continued with the same conduct, in our view, which she displayed at Marikana because she even lied to you. So the President has never said that, she lied to him. In fact, in the term of reference, he refers to the very same representations which he made to show that he was aware of the representations which she made to her. But when he comes with the terms of reference, which are 5, all of them are 5, he does not include that part because he does not say that she misled him. They can come today and say that they want to persuade you that she lied in the representations. It's outside the terms of reference, which they say that they understand them to be in paragraph 3 of the statement of case. So that's the context in which then we are saying that they will not be permitted. So, in fact, then let me put it this way. It is not suggested for a moment that the evidence leaders are not entitled to adduce evidence. In fact, we can never say that because that is part of the minutes of the meeting that was held here at the strategy meeting, that they can adduce evidence. But then it must be evidence which is in relation to the terms of reference. So it means that each time when they want to adduce evidence, they should persuade you that this evidence is actually in accordance with the terms of, the terms of reference, and it is relevant. In fact, if I can take you, Chair, to the letter which you'll find in now then Exhibit A, page 83. That is now then page 83. That is the letter which was addressed by yourselves to an organization called SERI. And what I submit is that what you captured in paragraph 2 applies with equal force to any party to these proceedings. Because what was succinctly captured here was that please note that SERI's application will only be entertained when its proposed evidence or submissions are not part of evidence leader's case and are relevant and of assistance to the board in making findings and recommendations on the board's terms of reference. So very clear. So the issue is not that they can't lead evidence. If they lead evidence, it must be evidence which is in terms of the terms of reference which are binding to this inquiry, and that it must be relevant. So it means that they must then pursue you what is the relevance of the evidence of certain witnesses who are not going to add anything or change the findings that were made by Falam. What we know is that Falam has made a finding, adverse findings, and it was on the basis of those adverse findings that the president established this board of inquiry. I cannot imagine a situation, Chair, where the evidence leaders are going to come here and say to you that they don't agree with the findings of Falam, or that they agree with this one and don't agree with that one, because they are basing their case on the adverse findings that were made by Falam, and they are embracing his conclusions thereat. So that is really the basis of that. So when they come, they must be able to show that how will this evidence which this witness will tender assist this board in ensuring that it executes its mandate in terms of these terms of reference, and how this evidence is in consonant with the findings that were made by Falam then against the National Commissioner. Otherwise, if we're to allow the evidence leaders then to come with anything outside the terms of reference, then we are now back to the general inquiry into her fitness. Then anybody else then can come with whatever allegation. We may as well even allow SERI to come, because SERI also wants to come here and then come with all sorts of things that they want to show that this person is not fit. So we're saying in brief, the evidence leaders in their statement of case understand exactly what the terms of reference are, and they've set out and they've accepted that the terms of reference bind them. You must have realized when Mr. Jamie was making his submissions, he never referred you to the terms of reference and as to how the evidence that he says that he wants to adduce is going to fall within the terms of reference. All what we're told is that their understanding is these terms of reference do not require any interpretation. They are clear and simple. You don't require any interpretation of these terms of reference. They are what they are. If you don't like them, you are not constrained, because you can always go back to the president and say that, Mr. President, these terms of reference make it difficult for us to prove our case. So please put them in a manner that it will enable us to put our case and to make it acceptable then to the board. So that is what then they're supposed to have done, but they failed to do so, and so therefore they are bound by the terms of reference as they are. So now so Mr. Jamie then says that you must read the terms of reference in conjunction with Section 9 of the South African Police Service Act. But then Section 9 then does not say anything other than telling us about the president having to set up the Board of Inquiry. But then the Board of Inquiry must have terms of reference. And those terms of reference are the ones which are going to guide this Board of Inquiry. And the same with Section 8. But then, if you look at these terms of reference again, one can see that the terms of reference, they bind the employer, that is the state or the president, because then that is what he wanted this Board of Inquiry to deal with and nothing else. But he takes cognizance of the rights of the employee. And when you look at the third page of the term of reference, then now it tells us about the rights of the National Commissioner in terms of Section 9.1. So, to be present here, to be assisted by a legal representative, to call witnesses, and to have access to documents relevant to the inquiry. It does not say anything about the evidence leaders, because it is clear that it is the National Commissioner who is being accused of misconduct. So she has the rights which are derived from the principle of natural justice, to a fair trial, to adduce evidence, to be present here, then to call whatever witness and so on. So now then the evidence leaders want to transpose the rights which are conferred on the National Commissioner, that those rights then axiomatically then also apply to them. But with them, they've made allegations, they must prove those allegations, and whatever evidence that they bring, it must be relevant then to the term of reference. If it is not relevant to that, then this inquiry will not accept it. So it's as simple as that. But what the evidence leaders did not do, which now takes me now to the fourth point, is now the evidence that they say they want to lead. Now, the manner in which the evidence leaders have presented their argument to you is that you must make your ruling in the abstract, that they are entitled to call witnesses. But it can't be. They must be able to say that we have the evidence of the following people, and this evidence we are asking permission or a ruling from you whether we can adduce that evidence, because there is an objection to that. So they're not doing that. I mean, we have agreed in one of these strategy meetings that no witness will testify unless that witness has made a statement under oath. And Mr. Jamie then has read then that part of the minutes. So what was anticipated is that the evidence leaders were going to give us statements of the witnesses who they want to call, and those statements will be under oath so that we can see what evidence these witnesses are going to lead. We are not told of who then they are going to call, who has made a statement under oath, and what is the relevance of that evidence. But I would like to do that myself, because then that is what this board has to consider when making its own ruling. What we have been given so far, we've been given only 4 statements. So what we can safely assume is that when the evidence leaders talk of calling witnesses, they're talking of calling only 4 people. And they can't tell us about other people today, which they've never told us about, or which they've not given us their statements. But they must give us the statements of those people under oath. So in their statement of case, they tell us that if we do not accept the evidence, the statement of Nhlanti, at Marikana, they want to call in Nhlanti. Then they say that if we do not accept the statement of Mawela, General Mawela, they would like to call General Mawela. If we do not, then they say that they also would like to call Advocate Jeff Badlander, SC.
Advocate who?
Jeff Badlander, SC. They say they want to call him so that he can testify about some consultation that he had with Mawela and about the notes which he has taken. Then the fourth person that they say they want to call, Adrio, who is in France. So those are the only four people that they've mentioned that they want to call. So why don't they say to this commission that, take for instance, here is a statement of Mawela. We would like to call him, he has given the statement, we have complied with the direction given by this board that we must get his statement under oath. We have done that, and here is his statement, and this statement is relevant because it accords well with the terms of reference. With Jeff Badland as well, why they say that they must come. With Adrio as well, they're not telling you anything. So on what basis must you be asked in the abstract to then say that they're entitled to call witnesses? So the statements that they're talking about, you'll find them.
Are you suggesting that they're not entitled to call witnesses?
No, I'm not suggesting that they're not entitled to call witnesses. I'm saying that they must, well, first they must have complied with the agreement or the decision that was made here. They give us the statements, and then when we object to that, that is the purpose of this application, now to say that.
So they can call whoever they want to, provided they comply with the preliminary requirements to submit a statement under oath to you of the particular witness they want to call. And then when they call the witness, you will be entitled to object to the relevance of that witness.
That's right. That's right. Yes. So what I'm saying is that so then they were supposed to have complied with that requirement, and they have not complied with that requirement. For instance, we talk of the statement of Adrio. Then Adrio, we have a statement from him. When you look at that statement, he was in Cape Town on the 22nd of April, flown all the way from France, because then apparently then he's still working for the South African Police Service, but he's been seconded then to Interpol, and is based in France. He's flown all the way from France to South Africa, come here on the 22nd of April, he signs a statement and he leaves. He doesn't sign it under oath. Whereas then, here it was very clear that give us the statement, then which of the witness will come then under oath, and then from there then we know that you have complied, and then we're able to take it on that basis. And the relevance of that statement, when he comes to testify, because we've objected, then we'll be able to object then to the evidence of that witness on the basis of relevance. So we're not saying that they're not entitled to call witnesses at all, but we're saying that the witnesses that they call must be able to assist this inquiry in relation to the terms of reference and the relevance of it. So given that, we're not even told about the relevance of any of the witnesses then who are supposed to come, then I will then assume that then those people then when they come, as long as they've complied with the decision, then they will be dealt with then on the basis of then the relevance of their statements. Just a moment. Okay. So just to recap, we say that on the first point of whether are they entitled to call witnesses, I was saying that just to recap then on the first point, whether they're entitled then to call witnesses, then we say that that has already been a decision, and then we have stated the basis of the objection and that there must be compliance with that. With regard to the second point is disposed of, Judge, by this term of reference 2.5 on page 3. No, it's 2.5. Yeah, 2.5 at the bottom, in the middle of the page. Let's read this term of reference. It says, the overall testimony by the National Commissioner at the Commission was in keeping with the office which she holds, and the discharge of her duties commensurate therewith. So the operative words there is the overall testimony by the National Commissioner, and then we underline there, at the Commission. So it's very specific, at the Commission. If the President wanted it to extend beyond that, we're not told what was difficult in him doing it that way in the statement, that the evidence, the President could have simply said, the overall testimony by the National Commissioner at the Commission and as well as her subsequent conduct thereat. What is so difficult in saying that? So the reason why that is not here is because that is not what the President wanted this Commission to focus at. And I want to make it clear that we are not actually even suggesting that what they are putting as a proposition in the statement of case when they say that she misled the President in the representations is correct. It is actually then not even correct, because you'll be able to read the representations and you'll be able to see that there is no misrepresentation or lying that you can find there. But we're raising it as a matter of law, as a matter of principle, that we cannot say that they must be allowed because the statement, the representations are favorable to us. They are favorable to us. We can demonstrate actually that they are favorable to us, but we are not seeking to get that benefit in circumstances where we know that that will be operating outside the scope of the term of reference. So we submit that, so term 2.5 is very clear, and you'll remember what Mr. Jamie submitted to you was in respect of how term of reference 2.5 reads. He said that our interpretation is, because he conceded that the literal reading of this is that it excludes any evidence outside Marikana. It excludes it. So why will this board be asked to read into this term of reference words which are clearly not there? So those are submissions that both points then should not be allowed. In respect of the first one, of course, there is a rider to it, then subject to the relevance, but in respect of the second point, we say that that must be dismissed outright. Thank you.
Mr. Jamie, it's now 12:30. Would you like to respond now and then we adjourn for lunch before we give a ruling? Or what would you like to do?
I'm happy to proceed on that basis.
Well, then I think, will you be able to finish before 1 o'clock?
Yes.
With your reply?
Yes.
All right. Please proceed with your reply and then we'll adjourn and then we'll give the ruling after lunch.
Thank you, Judge. I'm going to deal with it in the order in which the submissions were made, but they do, because the submissions covered both bases or both issues, it might be a bit disjointed. To begin with, the submission that we as evidence leaders and the members of the board cannot amend the terms of reference. Obviously, this board and the evidence leaders cannot amend the terms of reference. But with respect, that's to misunderstand the argument. We've not suggested or submitted that what we are referring to would constitute an amendment of the terms of reference. The submission, and this goes obviously to the second point, the proper ambit of 2.5. 2.5, the submission is must be purposively interpreted and so as to enable this board properly to carry out its function, which is to conduct an inquiry mandated by the President in terms of Section 9(1) of the Police Act, to inquire not only into allegations of misconduct by the National Commissioner, but into a fitness to hold office and a capacity for executing her official duties. And that is a broad investigation. It's an investigation. One can't be unfit, or rather, put it the other way, you can't be fit for certain purposes and not fit for other purposes. You're either fit to be National Commissioner or you're not. You either have the capacity to carry out your functions efficiently and according to law, or you don't. You can't divide it up in an artificial manner and say, and we submit, we've made the submission to you, how you should read the terms of reference, and in particular 2.5. The next submission I want to deal with is the submission that the board must make a decision as to what, the submission was that the board must decide, and that came after an exchange with you, you may recall, the board must decide for itself what the terms of reference mean. And we agree entirely with that. The board must interpret the terms of reference. That contradicts a subsequent submission by Mr. Mukari that there is no question of interpretation involved in construing the terms of reference. We submit that can never be. The terms of reference are a written instrument, and any written instrument has to be interpreted by those who must give effect thereto. So that argument with respect is not correct. Then there was an argument that was based, members of the board, on paragraph 3 of our statement of claim, statement of case. And Mr. Mukari referred there to the particular wording of that paragraph, and in particular to the statement in the paragraph that it is clear that this is not a general inquiry into the fitness of the National Commissioner, but is confined to the conduct of the National Commissioner in relation to the events at Marikana, and then the party relied on, and her evidence in relation thereto at the Farnham Commission. Now you'll recall, Judge, that elicited another response from you, where you pointed out to Mr. Mukari that a position, an opinion, particularly an erroneous opinion on the part of the evidence leaders can't bind this board as to the ambit of your powers, and that must be correct, and he conceded it. But just to put in context, 3 does say what it says, but paragraph 7, 4 paragraphs later, says the following. Finally, it is clear, and this is the concluding paragraph to this section of the submission. Finally, if it is clear that the National Commission's evidence demonstrates a woefully inadequate appreciation of the role and of the national security implications of the police's conduct in Marikana, or if she made herself guilty of misconduct in her interactions with the Commission or the President, then it must be concluded that it has been demonstrated that she is not fit for office. So while there may be a contradiction between the 2 paragraphs, we submit the concluding paragraph makes it very clear what our position is. And that's the position that we contend for this morning. Then there was the submission that the President had a response, and if he considered that she had lied to him, he could have amended the terms of reference. With respect, the submissions that we make based on her response to the President when seen in the light of the evidence at Marikana and other material, such as the police's heads of argument at Marikana, which we refer to as well, that is a mosaic of evidentiary material which we submit this board is entitled to, if not obliged to look at, in reaching a conclusion in terms of Section 9.1. And the President, with the greatest respect, has other matters on his table. It cannot. That is why he has appointed this Board of Inquiry to conduct an inquiry which he obviously is not able to conduct himself. So the suggestion that he would have known or suspected that, if it is indeed so, that the National Commissioner has been less than frank in her responses to him, with respect, that's a non sequitur. The fact that he had the representations does not mean he would have appreciated the relevance thereof in the context of evidence at Marikana, which runs to more than 600 pages, I might add. Then the next submission And it really is, yes, I think it's a submission that was made at the end. And with respect, well, let me first deal with the position now adopted in relation to the calling of evidence, the calling of witnesses. Mr. Makari has now disavowed any position on the part of General Phiyega that we as evidence leaders are not entitled to call witnesses. But if he does that, then he must obviously disavow what is stated in paragraph 55 of the statement of response. Because let me just read this to you again, and it's got nothing to do with relevance or with its reference to or with its connection to the terms of reference. This is the position adopted by the National Commissioner in writing in a response to this Board of Inquiry. And I've read to you already the passage that says we are entitled to call witnesses who testified at Marikana, but only to clarify their evidence. That's the first part of paragraph 55. This is the second part of paragraph 55. It is, however, impermissible for the evidence leaders to call witnesses who were at all relevant times available to testify at the Parliament Commission but were not called, or to call witnesses who testified at the Parliament Commission in order to bolster the evidence which they've already led at the Parliament Commission. Any attempt by the evidence leaders to call the witnesses as they have alluded to in their statement of case will be opposed. Now, with respect and with reference to Mr. Makari's submissions to you about what case they thought they were here to meet, we, in agreeing to these preliminary arguments, understood this to be the case we had to meet. There was no case made to us that you have not given us statements under oath. There was no case made that witness X, Y, and Z are not relevant. There wasn't even a query. And our learned friends have the bundle of correspondence, and if there is, if I'm wrong, they'll correct me. We're not aware of any query as to what is the relevance of witnesses X, Y, and Z. And can I just explain this? When we're told that there are only 4 witnesses, we seem to be at odds with each other here. The way we prepared our case, rightly or wrongly, and if we have fallen foul of any procedural aspects, one of them was raised in conference earlier this morning, then that can be, we submit, addressed, and in fact there was a very sensible suggestion as to how Captain Adria's situation can be addressed. But the way we presented our case in the statement of case was there is reference throughout the document, and it's not correct to suggest that we've not indicated the relevance of each proposed witness to a particular term of reference. As you'll know from having read our document, we make preliminary remarks, then we deal with each of those terms of reference separately. And in the course of dealing with each of them, we reference and we say, this is what a witness said, or this person wasn't called, is available. If the National Commissioner disputes it, we will call the witness. And that was done in order to not unnecessarily burden the Commission with hearing evidence that's not to be disputed. That is the only reason it was given as, if you do dispute it, we'll call the witness. Because it makes no sense to call witnesses, to simply call them, say, did you make a statement, and then there's no cross-examination. That's a waste of everyone's time. So it was thought a sensible manner to proceed. But we had a list with cross-references that my junior advocate Kusovitska has prepared of no less than 14 potential witnesses. In each case referenced to where to be found in the statement of case. And in each case, you will recall, or maybe not, but if you do look at our statement of case, in every single case, except for witnesses where no statements were taken, such as Advocate Budlander, in every single case we give the reference of the exhibit, we give the exhibit number. Because remember, all these statements were handed in at the end of the Parliament Commission as exhibits, even though witnesses were not called. And that is the reason why we deal with it in that manner. So it's not correct there are only 4 witnesses, and it's also not correct that we haven't explained the relevance we have in our document. And again, subject to any correction by my learned friend, there is no dispute, or let me not overstate the position. In certain cases, they say this witness would be entirely irrelevant. But the proper time to raise that argument is when the witness is called, unless we can, by agreement, agree that the witness is irrelevant. This was never intended, this morning, or it's now into this afternoon, was never intended as an assessment of the relevance of any particular witness, because the objection was the broad one, not that witness X or witness Y is not relevant. And I simply have been caught by surprise that that argument is made. I wasn't prepared to deal with that argument. But our submission is that we have dealt with it in our statement of case. And I'm not going to repeat the argument with regard to the second point we've made our submission.
Do you agree that the relevance of any witness that you call will always be a matter for decision as the witnesses are called?
That's the only time that you can, yes. It's not meant to be at the risk of repetition, the objection was, as I read in paragraph 55, it was we will object to any of those witnesses being called, not individual witnesses, to any of them being called, because they were not called at follow. That's the objection. And we've dealt with that, we believe. Thank you, Judge.
Thank you, ladies and gentlemen. We will now adjourn for lunch until 2 o'clock, and we will then hand down our ruling in regard to these two preliminary points at 2 o'clock. Thank you. Adjourn. point raised by Mr. Jami for the evidence leaders, it would seem to us that the discussion and the concession made by Mr. Mukari would result in the answer to the first question to be that the evidence leaders would be entitled to call witnesses, but that witnesses' evidence will have to be tested at the relevant time when they are called as to their relevance to the terms of reference. Let me then deal with the second point, and that is the point whether the evidence leaders would be entitled to refer to instances ex post facto, the Farlam Commission, where the National Commissioner is concerned. Mr. Bukhari was at pains to argue that the proper interpretation of the last terms of reference 2.5 indicate clearly that any reference to subsequent conduct by the National Commissioner would be inadmissible and beyond the terms of reference of this inquiry. However, in the statement of defense, the counsel for the National Commissioner itself admitted that the terms of reference in paragraph 2.5 is vague and unsubstantiated. Paragraph 45 of the statement of defense, the following is said, and I quote, "The term of reference relating to the overall testimony by the National Commissioner at the Commission being not in keeping with the office she holds is vague and unsubstantiated. The evidence relied upon is not identified, nor is it explained how she could have made herself guilty of misconduct by virtue of the evidence that she gave at the Farlam Commission of Inquiry." Unquote. It stands to reason that the representations made to the President by the National Commission after the Farlam Commission had completed is relevant in the sense that in those representations she sought to explain her conduct and her evidence and the evidence that was led at the Commission in order to establish her absence of any guilt. In doing so, in that particular representation to the President, she therefore incorporated her conduct at the hearing before the Farlam Commission. It would therefore be absurd to suggest that her statements in that representation is of no consequence and irrelevant to these proceedings. Her explanation to the President related to her very conduct at the hearing of the Farlam Commission, and in our view, therefore, is relevant for the decision that has to be made by this Board of Inquiry. We are therefore of the view that the evidence leaders would also be entitled to refer to such conduct after the conclusion of the Farlam Commission, which has a direct relationship with her conduct at the hearing of the Farlam Commission itself. It goes without saying that if she was to testify at this Board of Inquiry concerning her conduct at the Farlam Commission, which flies in the face of any subsequent conduct where she explained her conduct, that would be relevant to consider her creditworthiness and her fitness to hold office. For those reasons, we are therefore of the view that in regard to the second point, the answer must be in the affirmative, that the evidence leaders would be entitled to refer in this Board of Inquiry to matters which occurred ex post facto, but have a direct relationship to what occurred during the Farnham Commission. In conclusion, it may just be said that anything positive or negative that occurred in the conduct of the National Commission post the Farnham Commission, which is entirely irrelevant to that commission, would not be permitted in this Board of Inquiry. There must be a direct relationship between such conduct ex post facto to the actual hearing and her conduct during the hearing. And for that reason, we make a finding or a ruling in regard to the second point, that the evidence leaders would be entitled to refer thereto.
As the board pleases.
Thank you, Chairperson.
Thank you. Now that we've made that ruling, Mr. Jamie, what is the next step?
Judge, the next step was we had lined up a witness for today, just abundante, and the witness is present. It is, and I'm sorry, I'm informed that you should have, each of you, a document titled Evidence Leaders Bundle.
Yes.
That has been put.
There's a big bundle to that effect, yeah.
Yes.
Is this the bundle you're referring to?
Yes.
Yes, thank you.
A copy has been given to our colleagues. Could I ask that this be labelled Exhibit B?
This will then be Exhibit B.
Court pleases. Judge, what this document is a compilation of statements, and in some cases affidavits, together with associated documentation. And in most cases, you would see that there is an exhibit number which is provided, and that would be a reference to the Farnham Commission exhibit numbers. And the witness, and the purpose of this is to act as a guide of the statements or affidavits together with the other documentation we'll rely upon in leading these witnesses, whom we do elect to call. And the witness we have at the moment is Mr. Pilani Tladanyani, who's number 8, the first witness on the second page. He's present, but his first language, and sorry, just to orientate you, you will find his statement at paginated page 69
Yes,
of this bundle.
we see that.
And it's difficult to read because it's been copied repeatedly, I think.
Well, it's not only difficulty, it's almost illegible, Mr.
That is why what we intend doing is having Mr. Tladanyani read this into the record, and then to deal with his evidence that flows therefrom. He has, however, requested me once...
With respect, I'm sorry to interrupt you, that would not be sufficient. You will have to ask somebody to retype this in typed form, because down the line, if we have to refer to it again in 2, 3 or 4 weeks' time, we may not be able to recall exactly what was written here. So
No. I beg your pardon, Judge. We will, and in some cases already it has been done.
yes.
The handwritten documents have been transcribed.
Yes, please.
So we will certainly provide a transcript, but perhaps it would be better to do that once he has read it into the record. But he has requested, once we explain the situation to him, his first language is Swana.
He's what?
Swana.
Oh, Tswana speaking.
And although he seems, obviously, he's written this in English, he would prefer to give his evidence through an interpreter. and we don't have one available this afternoon.
Well, how do you propose to solve that problem, Mr. Chairman?
We propose we don't have any other witness for today, Judge. So we propose I've asked my attorney and the Secretariat between them to arrange for an interpreter.
All right.
And we intend to call him later this week, with your leave.
Are you suggesting that we then adjourn until tomorrow morning at 10 o'clock for this witness's interpreter to be obtained and to be ready to proceed at 10 o'clock tomorrow morning? Is that what you're suggesting or not?
Not as precisely as that, Judge, because I do not have control over the interpretive services that are available.
Where were you thinking of obtaining the services of an interpreter?
Via the Secretariat or my attorney.
Yeah, all right.
I personally don't arrange interpreters, Judge.
Yeah, well, I appreciate that. Coming from Cape Town, you don't know all the interpreters here, do you?
I don't, Judge. So I would like we do have witnesses for this week, but they're not always going to flow seamlessly from one to the other, Judge.
Subject to what Mr. Mukari has to say, if we were to adjourn until tomorrow morning, then wouldn't that allow you ample time for your attorney or somebody else to transcribe these statements, at least this first one that you wish?
We certainly can have this one transcribed.
Yeah.
Yes.
And later on the others then as well.
Any statement in this bundle that's not been transcribed, we will transcribe.
Thank you. Mr. Mukari.
Chairperson, we have no objection as long as then the stand down is to tomorrow morning. And insofar as obtaining the services of interpretation is concerned, then they should be able to get assistance from the Office of the State Attorney, and we also have the Director of Public Prosecutions, the interpreters from court. It's not a difficult thing, especially given that Setswana is a language that is quite well spoken in this area. It should never be a problem. So it will cause no problem if we stand down to tomorrow morning at 10.
Thank you. Okay. Anything further you wish to say, Mr. Chairman?
Mr. Tlangiani is certainly available tomorrow morning, and
Yes.
subject to what Mr. Mukari has said. If the interpreter is available tomorrow, we will start with him at 10.
Well then, I think we shall initially adjourn to 10 o'clock tomorrow morning in the hope that you're ready to proceed then. If not, then I think you should explain to us what the problems are with obtaining the services of an interpreter. Will you do that?
I certainly will, Judge.
And what we also suggest, Chairperson, is that the evidence leaders should not rely on one witness only, because they've had an opportunity for 8 months to line up their witnesses. So if then he can't put this witness first, he must put another witness tomorrow. So it can't be a reason for that, because they've had 8 months then to do that, and especially given that we have not been given even the list of the witnesses and the chronology by which they're going to be called. So if then they can also do that this afternoon and give it to us, then we know that who is the next witness and so on. We're able to prepare accordingly. Thank you.
Judge, as I've indicated, the availability of witnesses and the practical difficulties in arranging them, putting them on standby, shouldn't be underestimated. We are operating from Cape Town, and it's not an excuse, but it's an explanation. We are divorced from the situation here. Till you made your ruling, the position was we weren't entitled to call any witnesses whatsoever, and that must be factored into the situation. As also the attempts between the parties, which you were apprised of this morning, to actually remove the need to call witnesses by agreement, as in the one with regard to Captain Riah that you heard this morning. So it's not that simple to simply have all these persons lined up. There, at least one of the witnesses, Captain Mulman, has family matters that have taken it to Cape Town, and we were told that, and we advised the secretary of that timeously that she would only be available on the 9th. So those are we're operating under various constraints. But subject to all of that, we have no desire to string this out, Judge. We will attempt to have the witnesses that we decide we do want to call, in light of your ruling, as conveniently lined up as possible. That I can give you my personal undertaking.
Would it serve any further purpose for the two legal teams to meet in regard to what witnesses are going to be called, to arrive at some kind of an agreement in regard thereto, or would that serve no purpose at this stage?
Could I respond first, Judge?
Yes.
You would know that, I think very reasonably, Advocate Makari was amenable, and that request was conveyed to you via the Secretariat, and it had the imprimatur of both of us, that we thought it would make sense, precisely to get all of these practical difficulties out of the way, to possibly have this ruling today, or this argument and then a ruling as you've given today, and then stand down to next week to have all the witnesses lined up. That was turned down. So under the circumstances, we are sort of trying to, as it were, reverse engineer the situation to have the witnesses here in light of the ruling.
Well, I think the response by Mr. Mukari will be, you had 8 months.
No,
Yes.
we've had since 15 minutes ago, Judge.
In fact, Judge, what I would like to propose is that the evidence leaders should make sure that from the 14 witnesses that they have, this inquiry does not stop at any moment. They should make it the point that they have their witnesses here. If this one is not available at the particular time, then they must have another one ready. And the question of Cape Town does not even arise, because the evidence leaders are instructed by the State Attorney Pretoria, and they're relying on the State Attorney Pretoria. They're not the ones who are running around looking for witnesses. So that cannot be used as an excuse. This inquiry has waited for too long, for 8 months. They've had that opportunity. So if they can ensure that this inquiry, it runs smoothly without the interruptions that they're suggesting. But insofar as the parties talking, we'll continue talking in respect of those witnesses that may not be necessary to be called. But the impediment here is that we have not been given the witnesses that they are calling. So that's why I'm saying that if they can give us the list of the witnesses that they want to call by this afternoon, we'll be able to sift through and look at their statements and see whether this witness is necessary for him or her to come. They have not given us that. If they can do that this afternoon, then of course, then some of the witnesses may fall away.
Will you be able to comply with that request? I think it is a request,
We've
Mr.
already,
Jamie.
well, it sounds like a demand, but we've already complied with, not complied, we've already done what is being requested, because they were given the witness bundle, and that lists the 14 witnesses, together with their statements and any other additional. It's the same document you've got, Judge. So they have
Is this bundle that you've
Yes.
given to us just now?
Yes, but all that is, with respect, is it's in order to assist. We're not obliged to provide a document like that, because that document, Judge, comes directly.
Exhibit B.
Exhibit B is a direct extract, or at least compilation, of what is said in our statement of case.
Yeah.
And the statement of case says who we're going to call, depending on what their reaction is. So they've known throughout who the likely witnesses are, subject always to agreement.
Well,
And we've now gone one step further and given them that document, which actually takes out all the relevant exhibits and puts it in their hands in one document. So I don't know how it can be suggested that
Yes,
we
but
have not given them that.
let me just interrupt you there, Mr. Mukari. I mean, you have here something like, I don't know how many witnesses.
Well,
I'm still of the view that neither the board nor Mr. Mukari knows exactly whether you want to call all of these witnesses or only some. And if you want to call only some, then tell us which are those that you are intending to call.
We certainly will do that, Judge, and subject to any agreement, as I indicated
I think
from the outset.
this afternoon should be then used to sort out these preliminary housekeeping issues with regard to the witnesses. And I would ask both counsel to cooperate in this regard, and for the sake of the brevity of the entire Board of Inquiry, to come to some agreement in that regard.
Yes, Chairperson, thank you very much. I understand the ruling that you have made today not to be exonerating the evidence leaders from complying with the agreement which is contained in the minutes, that when they call that witness, they must show you that they've complied with it. They've given us that statement, it's a statement under oath, and then from there we can test the relevance of that evidence. This bundle which has been referred to you, which has been extracted from some of the documents in the bigger bundle, which then we have just been given just now, then 2 minutes before you started handing down your ruling today, then if you can just flip through it, the first page is a handwritten statement, and when we look at it at the end, then we look at the next statement, some are commissioned, some are not commissioned. So they know that they must make sure that in respect of those who are coming to testify, they must show us that they've given us a statement which is commissioned. They can't give us the statements which are not commissioned, they say that they've complied. So that's all what I'm saying. But in respect of signing out other things, as soon as they give us the list of who they want to call, then we'll be able to know the statements of those people, and we'll look at them and we'll be able to engage whether it is necessary for that person to be called or not. It's just as simple as that.
I'm sure we can resolve this
I think
afternoon.
let us terminate the discussion now. I wish to prevail on both counsel to be reasonable in these circumstances and to assist the Board of Inquiry in trying to terminate the length of this inquiry as best they can. Okay?
Thank you, Chairperson.
Thank you. Then we'll adjourn until 10 o'clock tomorrow morning.